Hello, everyone. A warm welcome to all those joining us from coast to coast to coast. My name is Riwa Mourad, and I'm your host for today's CEA Conversation Series webinar. Je souhaite la bienvenue à tous ceux qui se joignent à nous d'un océan à l'autre. Je m'appelle Riwa Mourad et je serai votre hôte pour ce webinaire de la série de conversations de l'ACE. I would first like to acknowledge Canada as the land of the First Peoples, Inuit and Métis. I would like to pay homage to the Indigenous peoples, past, present, and future, that continue to work, educate, and contribute to the strength of our country. I would like to recognize that the land is shared through historic treaties, developed through contemporary treaties, and one that continues to be unceded territory. The Canadian Electricity Association has been working very closely with our corporate partners to develop an ongoing conversation that focuses on solutions to current and future challenges faced by our industry. L'Association canadienne de l'électricité collabore avec ses entreprises partenaires afin d'élaborer une conversation continue axée sur des solutions aux défis actuels et futurs auxquels fait face notre industrie. For today's webinar, McCarthy Tétrault and Stephanie Axman's presentation will be focused on Indigenous rights in Canada, a review of significant legal and constitutional milestones. This webinar will provide you with an overview of the most significant legal and constitutional milestones relating to the recognition and evolution of Indigenous rights, titles, and treaty rights in Canada. Our presenters today will trace certain key developments in Indigenous rights from the Royal Proclamation of 1763 to the present, including historic and modern treaties, the recognition of Aboriginal and treaty rights in Section 35 of the Constitution Act, 1982 and related jurisprudence, the duty to consult, and Canada's commitment to implement the United Nations Declaration on the Rights of Indigenous Peoples, UNDRIP. They will provide you with a historical and contextual framework for understanding the unique challenges and opportunities in Canada for the implementation of UNDRIP and the ongoing pursuit of reconciliation. A few housekeeping notes before we begin. Our session today is scheduled to run for an hour and a half. Notre séance aujourd'hui devrait durer environ 1h30. While everyone has automatically been set on mute, we do encourage your participation. As questions come to mind, please feel free to type them into the question box in the control panel on the right-hand side of your screen. Questions concerning the presentation will be answered after the webinar. A link to the recording of this webinar will also be circulated to all participants along with a post-webinar survey. We would certainly appreciate your feedback. We would also be interested in any recommendations for future topics that you would like to see as part of the conversation series. It is now my pleasure to introduce our moderator for today's webinar, Wayne Rood, Director of Aboriginal Relations at Sask Power and the Vice Chair of CEA's Indigenous Relations Committee. Over to you, Wayne.
Thank you, Riwa. Welcome everybody for joining us today on this webinar. I'm going to introduce our two panelists, Stephanie Axman and Bryn Gray. I think they're going to provide Stephanie will be providing an overview of the significant legal and constitutional milestones in Indigenous rights in Canada. It is a very complicated topic, steeped in history. And I think having that background is helpful for people to move forward in the work that they do in Canada and in Saskatchewan and other provinces. So with that, I want to introduce Stephanie Axman. She's a lawyer based in Vancouver and Victoria, where she maintains a solicitor's practice in Aboriginal law. She has advised clients across industry sectors on a range of natural resource, project development, and commercial developments in BC and across Canada. Stephanie recently joined the Indigenous Legal Relations Unit with BC Ministry of Attorney General, prior to which she practiced Aboriginal law at McCarthy Tétrault with Bryn. She's providing this webinar in her personal capacity today. Our other panelist is Bryn Gray, is a partner at McCarthy Tétrault, specializing in Aboriginal law. He regularly advises clients on Aboriginal issues relating to resource development, energy and infrastructure projects, including consultation and accommodation, negotiation agreements, litigation risk management, and approvals with respect to the use of reserve land. He has also acted as counsel in Aboriginal litigation and worked in and for the federal government on Aboriginal issues, including as a ministerial special representative for Indigenous and Northern Affairs Canada on consultation and accommodation. So with that, I'm going to turn it over to Stephanie to begin the presentation.
Hi. Okay, hi everybody. So with that, just going to make sure that I can move the slides, which is not letting me do that right now. There we go. So here we are. This is our presentation, and we really appreciate having the opportunity to speak with everyone today. Obviously, it's a huge topic and with minimal time, so we're just really going to hit on the highlights we think of, some of the most significant aspects through history in Canada of the development of Aboriginal rights and title in Canada and leading up to the present day, really to give a contextual background as to what's happening now with the attempts and efforts to implement UNDRIP in Canada, to give you a sense of the challenges in that and how against the historical framework government is attempting to do that. So Bryn and I, we worked together at McCarthy, and now we're just happy to be working together as colleagues to present this to you. So Rewa and Wayne have given a good background for you, but really what our objectives today are is to help you develop your understanding of the sources and background of Indigenous rights and title in Canada. Some of you may be very familiar with a lot of this, but hopefully there's some new information in there or something that may refresh your mind. We want to provide a general framework about the constitutional protections for Indigenous rights in Canada and the most significant cases up to the present day regarding Aboriginal rights and title. And then again, to recognize the challenges of UNDRIP implementation in Canada within this context. So with that in mind, we've set out 3 parts to our presentation: the historical aspects, the constitutional and legal aspects, and then a discussion about UNDRIP. And lastly, there'll be time for questions. So historical foundations, I mean, the main document I think that we look to in a historical context about how the Crown in Canada has recognized and formally protected Aboriginal rights and title goes back to 1973 and the Royal Proclamation of 1763. What this document did was, once the British, I'm not a historian, but I'm going to tell you to the best of my ability, when the British won a large amount of North American territory from Britain, from the French in 1763, what they did was they issued this proclamation to set out the jurisdictional parameters of settlement across North America. And on this map, you'll be able to see there's a red line, or the colony line, and then anything to the west of this line was essentially forbidden from further settlement, and it was designated as Indian reserve lands. So they forbid settlers from going further west unless the Crown was able to negotiate treaties with the Indians to the west of that. So what happened with that was, I think that was one of the main reasons, or one of the factors why the colonies were upset with Britain by not allowing them to move ahead with settlement, in addition to taxation, which eventually led to the American Revolution. But the significance of that really is that by the terms of the proclamation, Britain was acknowledging that Aboriginal title existed across North America and continued to exist unless it was ceded by treaty. And I've given you some language here within the proclamation which is important, where the British state specifically that the lands have not been ceded or purchased by us, and they are reserved to the Indigenous peoples as their hunting grounds. And then the other significant aspect was that only the lands of the Indigenous peoples could only be ceded to the Crown. So those are the most significant aspects of the Royal Proclamation, and really set up in Canada this aspect of not conquering or taking lands by conquest, but rather in a more orderly manner and lawful manner by treaty. So that distinguished the Canadian lands from the colonies in America. The most significant case on Aboriginal rights and title for almost 100 years following that was the St. Catharines Milling and Lumber Decision. And that essentially was a jurisdictional dispute between Ontario and the federal government as to whether the federal government had the authority to grant logging permits to a particular company, or whether Ontario was able to do that. And the land had been ceded under Treaty 3. And it was the Privy Council that held that essentially the federal government did not have the authority to do that because it infringed Ontario's provincial jurisdiction, and the land was subject to the control of the province. But what matters from the Indigenous rights perspective is that the Privy Council held that although Aboriginal rights and title exist and they're a personal and usufructory right of Indigenous peoples, the Crown holds the underlying title, and fundamentally Aboriginal title was granted by the Crown by way of the Royal Proclamation. So in other words, it was not a pre-existing right, and then therefore the Crown would be able to extinguish the title at its own will. And this was the leading case on Aboriginal title until the Calder Decision in 1973. And this was a British Columbia decision that went up to the Supreme Court of Canada, where the Nisga'a were seeking a declaration of title in their traditional territories. The Supreme Court was split on whether the title actually continued to exist in their area, but it was unanimous in determining that Aboriginal title had existed, and it was a pre-existing right that it was not dependent on legislation, treaty, or otherwise. So it rejected the St. Catharines Milling decision, saying that it was a pre-existing, Aboriginal rights were pre-existing, that they flowed from Aboriginal people's traditional use and occupancy of the lands prior to European settlement. And this ultimately led to the modern treaty era and the comprehensive land claims process that the federal government put into place, which Bryn is going to discuss. And it took a while for the BC government to actually move forward with their own treaty process in 1992. And then the Nisga'a final agreement was ultimately reached in 1998. So Bryn, I'll move it over to you.
Sorry, I think I was on mute. Can you hear me? Okay. So I'm going to be speaking, as Stephanie said, about in this section about treaty making, both before and after the Calder Decision, and then I'll briefly discuss the Indian Act and other assimilationist policies before I turn it back to Stephanie to talk about Section 35 of the Constitution Act 1982. So there are two overarching types of treaties in Canada. There are historic treaties that were negotiated between 1701 and 1923, and there are modern treaties, which are treaties that were negotiated and concluded after 1975, following the Calder Decision. These treaties collectively cover much of the country's landmass, but historic and modern treaties differ significantly in their purposes, terms, length, and the manner in which they were negotiated. Dealing first with historic treaties, there are approximately 70 historic treaties recognized by the Government of Canada. The initial historic treaties negotiated by the British were prior to the Royal Proclamation of 1763 and primarily focused on ensuring peace and facilitating trade with First Nations that had allied with the French at various times. These treaties were negotiated mainly in the Maritimes in the Gaspé region of Quebec and did not include land surrender provisions. After the Royal Proclamation, the focus of treaty making changed, and treaties were largely negotiated for the purposes of opening up large portions of present-day Canada for settlement and development purposes. Can you go to the next slide? So, as I mentioned, the treaties negotiated after the Royal Proclamation generally included land surrender provisions, whereby signatory First Nations agreed to surrender their rights and title in specific tracts of land in exchange for lands being set aside for reserve, rights to hunt and fish throughout the treaty area, upfront compensation, and treaty annuity payments. The benefits ranged depending on the treaty, but those were some of the common things that were found in a lot of the treaties. These treaties generally contain clear language around land surrender that is considered by the federal government to have extinguished Aboriginal title. And so you have an example on this slide of language from the numbered treaties, which cover much of a large portion of Canada from northern Ontario to northern BC, including parts of the Northwest Territories. However, it's important to note that many Indigenous groups do not share the view of the federal government on some of these historic treaties. Go to the next slide. So in looking at the differing interpretations of historic treaties, it's important to note that most of these agreements were negotiated orally and subsequently written up by the Crown. And as a result of that, some Indigenous groups dispute the validity of the land surrender provisions or take the position that the language in the written treaty doesn't reflect the oral agreement of the parties at the time of signing, and that the treaties were intended to facilitate the sharing of lands rather than the surrender of title. And there have been many court cases about the scope of historic treaty rights and limitations related thereto, particularly in the context of harvesting rights. There really hasn't been any major cases that are focused on the validity of the land surrender provisions yet. There have also been many ongoing disputes between the Crown and First Nations about unfulfilled treaty obligations, including land and other rights. And we're seeing an example of one such dispute in the news right now with the Mi'kmaq lobster fishery dispute in Atlantic Canada, which I will be discussing later and arises from the Peace and Friendship Treaties. In the court cases considering historic treaties, the Supreme Court has said that historic treaties need to be interpreted generously and that ambiguities are to be resolved in favor of First Nations, given the circumstances in which they were concluded. And it's largely because they were negotiated orally. They're often stated in kind of lofty goals and objectives, and the First Nations were not represented by counsel at the time that these agreements were negotiated. So it's important when looking at historic treaties to remember that there may be a different perspective on what was agreed to than what may be written on the page, and that treaty interpretation will be informed by historic documents and oral history evidence. It's also important to underscore that these treaties, like modern treaties, do not impact the rights of non-parties, and thus there can be other groups in areas that are the subject of historic treaties, like the Métis or other First Nations, that may assert rights in those areas and are not covered by the historic treaty or not impacted by the historic treaty. Can you flip to the next slide? So turning now to modern treaties are treaties that have been concluded since 1975, and these have been concluded in Quebec, Labrador, the territories, and BC, with both First Nations and Inuit peoples. The slide in front of you is a map of modern treaty and self-government agreements in Canada, and there have been 26 modern treaties reached since 1975. You can go to the next slide, Stephanie. Modern treaties are much more detailed and lengthy agreements in comparison to historic treaties. These agreements are ones that have been heavily negotiated and confer a much broader range of rights and benefits, from harvesting rights to subsurface rights, consultation requirements, self-government provisions, fee simple land ownership, and significant capital transfers. The inclusion of self-government and a lawmaking authority is a significant difference between modern treaties and historic treaties. And in the case of First Nations, it allows First Nations to get out from under the Indian Act. Whereas in the case of historic treaties, you have First Nations that are signatories to historic treaties, but they are subject to the Indian Act and a lot of control by the federal government and don't have self-government. The first modern treaty was the James Bay and Northern Quebec Agreement. And the negotiation of this agreement began in 1973 following the Calder Decision and a decision of the Quebec Superior Court that granted an injunction to stop the construction of the James Bay project at the request of the Cree and the Inuit. And because this project was proceeding without any level of consultation, and then there were asserted rights that were being impacted by the project. This injunction was ultimately overturned by the Quebec Court of Appeal, but it created significant uncertainty about the project and the potential to sue for damages down the road. And so as a result, the Quebec and federal government really were pushed to the negotiation table with the Cree to try to reach an agreement. And that resulted 2 years later, very quick in terms of negotiation of modern treaties, from negotiation of modern treaty standpoint, it resulted in an agreement 2 years later. Now, modern treaty negotiations are primarily happening in BC because there were very limited historic treaties in BC, just Treaty 8 in parts of northern BC, and then there are some historic treaties on Vancouver Island, but the rest of the province was not subject to treaties. So a lot of the modern treaty negotiations are proceeding in BC through the BC Treaty Commission process. And the federal government is currently working on a new directive to guide treaty and self-government negotiators, and it is apparently going to be guided by UNDRIP. And of course, the approach to modern treaty negotiation has evolved over the past 20 years or 25 years, and so it remains to be seen what these additional changes will bring in terms of treaty negotiations. But like historic treaties, there are also ongoing disputes about the Crown not honoring modern treaty commitments, and there's been litigation about breaches of modern treaties, and that has led to the previous government introducing a directive around modern treaty implementation and establishing an office to ensure better implementation of modern treaties going forward. If you go to the next slide. So before we get to the Section 35 of the Constitution Act, I want to briefly touch on the Indian Act and the legacy of residential schools, as it is really an important part of the history of Indigenous peoples in Canada in the context of the rights discussion and the reconciliation discussion. Now, the Indian Act only applies to First Nations. It notably does not apply to Métis and Inuit. The legislation was first introduced in 1876, and since this time, it's allowed the federal government to control most aspects of life for First Nations people that reside on reserve. Among other things, it defines who constitutes an Indian for the purposes of the Indian Act. It controls the use of reserve land and related decision-making, and it significantly limits the jurisdiction and decision-making of band councils, leaving a lot of important decision-making in the hands of the minister or his or her designate. Now, it was even more restrictive historically and previously included very clear assimilationist policies, including forbidding First Nations from hosting potlatch and other cultural ceremonies, prohibiting the formation of political organizations, and denying First Nations the right to vote and retain legal counsel. The Indian Act has been widely criticized by all parties, but there really is a lack of consensus on how to replace it. Prior efforts have failed to date, including efforts under the current government. And really the only thing that has succeeded so far are really incremental efforts to establish alternative regimes where First Nations can opt out of certain provisions of the Indian Act, such as the First Nations land management regime or the First Nations election regime. Now, the First Nations land management regime has been one that's been particularly successful, and it allows First Nations to opt out of I think like 30 land management provisions in the Indian Act, and puts the decision-making into the hands of band council rather than the hands of the minister. And so the First Nation itself can make land management decisions in terms of the development of their reserve land, including entering into agreements for leases with third parties, rather than going through the cumbersome Indian Act process where the minister has to be involved and party to head lease and then lease back to third parties. Next slide. The last slide I want to address is just talking about assimilationist policies, and particularly residential schools. The residential school system was another major component of federal assimilationist policies that forcibly removed Indigenous children from their homes and was really designed to, quote, take the Indian out of the child. These schools operated from the 1980s until the last school closed in 1996, so a very long period. And I'm sure everyone on this call is familiar with the horrible chapter that this was in Canadian history, and the terrible physical, sexual, and psychological abuse that children suffered, and the many children that died at these schools. This experience continues to impact survivors and has had significant intergenerational effects on Indigenous families. And I raise this briefly because it is really an important aspect of the history of Indigenous relations in this country, along with many other unfortunate chapters like the 60 Scoop, day schools, and the forced relocation of some Inuit families to the high Arctic, just to name a few. And the residential school system is also part of the history that has led to the push for the federal government to implement the UN Declaration on the Rights of Indigenous Peoples. As part of the class action settlement relating to residential schools, the federal government established the Truth and Reconciliation Commission, which released 94 calls to action, including for the government to fully implement UNDRIP and adopt it as the framework for reconciliation. And when you look at the calls to action, UNDRIP is mentioned throughout the calls to action as a basis of many of the calls to action and as a framework for reconciliation, which is different from Section 35, which has been the existing framework for reconciliation to date, which Stephanie is going to talk about now.
Thanks, Bryn. Okay, so we're going to move on to part 2, the constitutional and legal recognition of Indigenous rights in Canada. And this is really going to take us through the Constitution Act and significant legal principles and the key court decisions that really set the foundation for Aboriginal rights and title today. So Section 35 of the Constitution Act 1982 is the most important constitutional protection that we have in Canada for Indigenous rights. And I would point out, and it's something that people may not recognize, is that in Canada, the constitutional express recognition and protection of Aboriginal rights is really very unique in a global context. I think that, and I may be incorrect by now, but up until very recently at least, Canada and Bolivia were the only 2 nations that actually included the express constitutional protection and recognition of Indigenous rights. So there's often criticism that Canada isn't doing enough, but what we have set down here is really a fundamental protection for Indigenous rights. So I'm going to go into that, the history of how this came to be and what it really means and is intended to do. So Section 35(1) states that the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. So it sets out that existing rights are recognized and affirmed. And Section 35(2) includes that Aboriginal peoples include the Indian, Inuit, and the Métis peoples of Canada. And Sections 3 and 4 of Section 35 were introduced a little bit later, but it was included to clarify that treaty rights they're included in Section 35(1), and those include rights that exist by way of land claims agreements or may in the future be acquired. And Section 4 provides that the Aboriginal and treaty rights are guaranteed equally to both males and females. Now, Section 35 was initially not included in the Constitution Act in the initial drafts, and it really came about by probably what I would consider the most successful protest effort by Indigenous peoples and supporters of Indigenous rights in Canada, in Canada's history. So it came about through a movement known as the Constitution Express. This was organized initially in 1980 during the initial drafting of the Constitution Act 1982, and it was a protest against the fact that Aboriginal rights were not included in the Constitution. There were thousands of Indigenous peoples that took trains from Vancouver to Ottawa. They protested in New York and in London, and ultimately it was those efforts to gain recognition for Aboriginal rights that resulted in Pierre Trudeau agreeing to include them. Now, initially, there was not really the expectation that that Section 35 would include the rights that the courts have ultimately developed over time with respect to Section 35. I'm going to talk about that later, how it's evolved over time and the court's understanding of what Section 35 means has evolved. Essentially, though, what Supreme Court of Canada has recognized that the purpose of Section 35 is the reconciliation of the prior presence of Aboriginal peoples in the lands of Canada with Crown sovereignty. And reconciliation, it's a common term that we know now. It's commonly used as sort of what is the ultimate goal of Crown Indigenous relations. The court has said that reconciliation under Section 35 is composed of two distinct aspects. One being reconciliation between the Crown and Aboriginal peoples, and 2, the reconciliation of the competing societal interests with Aboriginal interests. Moving forward, we recognize that there, and the Supreme Court of Canada has recognized that while needing to protect and affirm the rights of Aboriginal peoples, there is also a corresponding need to do a balancing between the other rights of Canadians and the country. So the Crown's duty to consult was developed primarily through the Supreme Court of Canada's decision in Haida Nation, and I'm sure you've heard of Haida Nation and generally the Crown's duty to consult. But I'm just going to go over the key principles because this is the most important case that continues to be relevant, and which, while cases moving forward have developed and provided context and additional detail to what consultation is and what the parameters of that are, this is really the foundational case. So the Supreme Court of Canada confirmed in 2004 that the Crown has a duty to consult and, where appropriate, accommodate Aboriginal peoples where the interests of Aboriginal peoples may be affected by a Crown action or decision. So I'm going to break that down a little bit for you. The Supreme Court of Canada stated that the duty to consult is a constitutional duty flowing from Section 35, as well as the principle of the honor of the Crown. And recently, courts have discussed the honor of the Crown in more detail, which we don't have time to go into today. But the fundamental principle is that the Crown must always act honorably and in good faith in its dealings with Aboriginal peoples. When the constitutional duty to consult is triggered, it is restricted to the specific Crown decision or proposal at issue. So it's narrowed to a decision that is being decided at the particular moment. It doesn't look at historical impacts, and it doesn't look at further decisions down the road. The duty to consult can be triggered by on-the-ground decisions, so things that are happening, for example, in the context of a project permitting decision, as well as higher level strategic decisions, which could potentially be regional planning or other types of forward-looking decisions that may have an impact on an Aboriginal right or interest. Now, an interest is required only. It's supported by prima facie evidence, but you do not need to have a proven right in order to trigger the duty. And that's important because there's often the question of whether an Aboriginal right exists, or how strong a claim is, or whether Aboriginal title exists or is claimed. But really all that is required is an interest that has some prima facie evidence. So the scope of consultation is determined by proportionality analysis, looking at the strength of the claims that are asserted, as well as the potential adverse effect on that particular Aboriginal right or interest. So there's a spectrum of consultation that is expected. It could be as low as providing notice of a decision or an action, to what is known as deep consultation, where consultation needs to be carried out and may require written arguments, hearings, opportunities to be heard, and so forth. Now, accommodation is the second part of the duty to consult, and that's not a standalone right. What happens is that through the course of consultation, good faith consultation may give rise to a need to accommodate, where there's a realization that yes, an Aboriginal right is going to be affected or may be affected, and there needs to be some accommodation to the Aboriginal group. So at law, we look at accommodation in terms of mitigation or avoidance, how to minimize impacts on Indigenous rights. For example, by changing the route of a project or changing the project design. At law, there has not been a lot of reference to what economic accommodation might look like, although impact benefit agreements and other forms of economic accommodation are very common, but that's not necessarily legally required, and we don't have that expectation, although in practical terms, that's what we see proponents and governments expecting. Consultation, really the the focus of consultation is on making it meaningful. That means that there's the opportunity for Indigenous peoples to express their concerns and for those concerns to be heard and responded to appropriately. However, this does not mean that the Crown is always going to meet the expectations of Indigenous groups, and it does not amount to a veto. And the Supreme Court and all courts across Canada have repeatedly held expressly that it does not constitute a veto right, and the only exception really is where Aboriginal title has been proven, and Bryn will talk about that a bit. Rather, it's a look at meaningful consultation and a focus on whether the outcomes have been reasonable and whether consultation has fallen with a range of reasonable outcomes. And again, in Haida Nation, the court noted this balancing requirement. There's a need to balance the broader societal interests with those of Indigenous peoples. And lastly, from the proponent side, there's not a constitutional duty on third parties. It's the Crown's obligation. However, the Crown can delegate procedural aspects of consultation, and that's practically what happens where proponents will take on the bulk of consultation because they have a general knowledge of the project at issue and can better respond to issues. We see now with the new environmental assessment legislation at the federal and provincial levels in BC that the Crown is sort of taking back some more of that procedural consultation in a way, I guess, in an effort to be more responsive to Indigenous rights and concerns. So there's going to be, I think, over the next few years, we'll see how that plays out with the balancing between Crown and proponents. But I don't think there's going to be a reduction of requirements on proponents, but rather a more fulsome approach by Crown, resource permitting, I guess. And then lastly, there's a reciprocal obligation on Aboriginal peoples not to thwart the Crown's good faith efforts to consult. And we see a lot of cases that hinge upon that, where an Aboriginal group has been unresponsive to consultation efforts. And the courts have then said, you are not now entitled to claim that consultation was inadequate because you did not fulfill your good faith requirement, reciprocal obligation to respond. So I'll turn it over to you, Bryn.
Great, thanks, Stephanie. So I'm going to speak for the next little bit about Aboriginal rights and title. Now, there have been many Supreme Court of Canada cases on Aboriginal rights, and I want to highlight two early seminal cases. These were the decisions in Sparrow and Vanderpeet. I'm going to briefly summarize both cases and then talk about some of the key principles that come from the cases. So the Sparrow case was a case about a Musqueam Indian band member in BC that was charged and convicted for fishing with a net that was longer than what was permitted under his license. In this case, the Supreme Court of Canada affirmed that the Musqueam had a right to fish for food and ceremonial purposes, and that Aboriginal right had not been extinguished contrary to the Government of Canada's position. It also sets out the test for determining what constitutes an infringement of an Aboriginal right and what circumstances an infringement can be justified by the government. The Supreme Court did not ultimately make a determination on this issue, but sent it back to trial in order to have a determination on whether the net restriction constituted an unjustifiable infringement. Now, the Sparrow decision was the first decision of the Supreme Court of Canada on Aboriginal rights under Section 35. But it really, in that case, there wasn't really a dispute that there was an historic Aboriginal right. It was whether or not the Aboriginal right had been extinguished. And so it wasn't until the Vanderpeet decision a few years later where the Supreme Court articulated the framework for determining what constitutes an Aboriginal right. And in this case, it's about a woman that was charged, a stolen woman that was charged with unlawfully selling fish caught under a license that was intended for food and ceremonial purposes. This is another case that arose in BC. And as I said, the existence of the historic right was in dispute. And the majority of the Supreme Court ultimately found in this case that the Section 35 right had not been established because the appellant failed to demonstrate that the sale or exchange of fish was an integral part of the Stolo culture pre-contact. Stephanie, if you could go to the next slide. There's a number of key principles about Aboriginal rights that come from these two cases. First, as Stephanie already touched upon, the Supreme Court in Sparrow indicated that Aboriginal rights recognized and affirmed by Section 35 must be directed towards the reconciliation of the pre-existence of Aboriginal societies with the sovereignty of the Crown. And so it really is the first case setting out this reconciliation, this notion of the reconciliation framework. And this principle of reconciliation as part of Section 35 is really fundamental to Aboriginal rights and all Aboriginal rights cases in the context of balancing what the courts have said in terms of providing a generous interpretation of Section 35 on one hand, with reasonable limitations on the other hand. Now, the court in Sparrow found that Section 35 did not create Aboriginal rights, but that they already existed and were recognized under the common law. The difference with Section 35 was that those rights could no longer be extinguished, and that any infringement of those rights had to be justified by the government. And the same is true with respect to treaty rights. Now, in Vanderpeet, the Supreme Court of Canada explained that to constitute an Aboriginal right, an activity must be an element of a practice, custom, or tradition that is integral to the distinctive culture of the Aboriginal group claiming the right. Now, in order to be integral, the practice, custom, or tradition must be a central and significant part of the society's distinctive culture pre-contact. Essentially, one of the things that made the culture of the society distinctive and what it was. And now it doesn't have to have been unique to the Aboriginal culture in question, but it has to have been a defining characteristic of the culture. There also needs to be evidence that the current activity at issue is rooted in pre-contact practices, customs, and traditions, but there doesn't need to be an unbroken chain of continuity, and Aboriginal rights are not frozen in time, as the Supreme Court has found. In considering Aboriginal rights claims, the Supreme Court of Canada clarified in Vanderpeet that courts must take into account the perspective of Aboriginal peoples claiming the right, but that perspective must be framed in terms that are cognizable to the Canadian legal and constitutional structure, because they exist within the general legal system of Canada. And this is again another notion of reconciliation and balancing of the common law and Aboriginal perspective. In the case of Vanderpeet, the Supreme Court of Canada ultimately found that the exchanges of fish were only incidental to food purposes, and there was no evidence that there was a regularized trading system amongst the Stolo people prior to contact, and there was a lack of evidence to suggest that the exchange of fish was a central part of the Stolo culture. So there was clear evidence that fishing was a distinctive part of their culture, but the court was really focused on whether there was clear evidence about the practice of selling fish or trading fish was a clear part of the culture pre-contact, and the Supreme Court of Canada found that there was insufficient evidence to establish this. Can you go to the next slide, Stephanie? The Supreme Court of Canada in Sparrow also set out the key principles for the doctrines of infringement and justification. In Sparrow, the Supreme Court of Canada explained that an infringement looks at whether the impact imposes undue hardship, is unreasonable, or prevents the rights holder from exercising the right. The onus is on the Aboriginal claimant to prove an infringement. Subsequent cases have clarified that an infringement occurs where there has been a meaningful diminution of the right, meaning that not all impacts to Aboriginal rights necessarily constitute an infringement, with the exception of established Aboriginal title, where the court has said that all impacts to established Aboriginal title constitute an infringement. In each case, the issue of infringement needs to be considered in context. And there may be a higher threshold for infringement in certain situations. For example, in a treaty context where the treaty allows for the taking up of land, like the numbered treaties, the court has said that not every taking up of land will constitute an infringement, but that an infringement will arise if an Indigenous group has no meaningful way to exercise their harvesting rights. And there is actually a case going on right now in BC involving the Blueberry River First Nation, where they are alleging just that all of the developments in their territory have left them with no meaningful right to hunt, and that has infringed their treaty rights under Treaty 8. Once an infringement is proven, the onus then shifts to the government to justify the infringement. This requires the government to prove several things. First, the government needs to establish that there is a valid legislative objective. The court in Sparrow noted, for example, that conservation and resource management would be a valid legislative objective. And subsequent cases from the Supreme Court have articulated a broader range of valid legislative objectives that could possibly justify an infringement of an Aboriginal right, including forestry, mining, hydroelectric power, and general economic development. However, in order to meet the justification test, you have to establish not only a valid objective, but go on to the second step, which is to establish that the infringement is justified and consistent with the Crown's fiduciary duty to Aboriginal peoples. And this can look at a number of factors, including whether there has been as little infringement as possible, if there's been compensation paid in the event of an expropriation, and whether the Aboriginal group has been consulted with respect to the measures. If you want to go to the, one last thing to note at the bottom of that slide. I've highlighted two cases that were Aboriginal rights cases involving First Nations, but the Supreme Court of Canada has articulated a modified test in the Métis context in Powley, which accounts for the fact that the Métis were not present at pre-contact and resulted from unions of European settlers and Indigenous peoples. And it defines what constitutes Métis for the purposes of Section 35 and sets out a modified test for Métis people to meet in order to establish Aboriginal rights. Go to the next slide. Most Aboriginal and treaty rights cases to date have been focused on harvesting rights and have arisen in the context of regulatory prosecution. These cases have looked at regulatory limitations on rights and the scope of harvesting rights in terms of whether they're limited to food, social, and ceremonial purposes, or whether there's a broader commercial harvesting right. There have been a few successful cases to date in establishing commercial harvesting rights, but they've been mainly limited to securing necessaries or a moderate livelihood. The Supreme Court has defined a moderate livelihood as covering the basic day-to-day needs such as food, clothing, and housing, supplemented by a few amenities, and not the accumulation of wealth or a broad open-ended commercial right. Now, the current situation in Nova Scotia with the launch of the Mi'kmaq self-regulated lobster fishery and the hostility and violence that has ensued is linked to one of these cases. This was a decision back in 1999 in which the Supreme Court of Canada affirmed that the Mi'kmaq had an unextinguished treaty right under the peace and friendship treaties to hunt, fish, and gather products to secure what was equivalent to a moderate livelihood. Due to the conflict that arose after this decision, the Supreme Court of Canada took a highly unusual step of issuing a clarification 2 months later, stating that the federal and provincial governments had the legislative authority to regulate the exercise of treaty rights where justified on conservation or other grounds. Now, 20 years have passed, and many Mi'kmaq feel that the federal government has not done enough and that the DFO licensing regime has still not recognized and accommodated their moderate livelihood right. As a result, the Sipekne'katik First Nation launched their own self-regulated lobster fishery before the lobster fishery was open this year. Now, they're insisting that their fisheries management plan ensures the conservation of lobster stock, but some commercial fishermen have argued that this should not be allowed at this time of year for conservation reasons. So I think when you look back at the second Marshall decision, the federal government clearly, in this case, has the authority to intervene and restrict the Mi'kmaq fishery if there are valid conservation grounds, but it has not done so to date. Instead, most recently, they have appointed a federal special representative to facilitate discussions between commercial and Indigenous fishers, and presumably are going to continue with their efforts to assist with the building up of the Mi'kmaq fishery through expanded licenses and commercial fishing vessels. Can you go to the next slide? Now, turning to Aboriginal title. Aboriginal title is the strongest form of an Aboriginal right, and to date there has only been one declaration of Aboriginal title in Canada. This was the 2014 Chilcotin decision of the Supreme Court of Canada that recognized Aboriginal title over approximately 1,700 square kilometers in West Central BC. Now, this decision built on the prior Supreme Court of Canada decision in Delgamuukw, and was an appeal of a 339-day trial spanning over 5 years. The Supreme Court of Canada affirmed in Chilcotin that there was a high evidentiary threshold to establish title, and specifically that an Aboriginal group must prove that they had sufficient, continuous, and exclusive occupation of the land at the time of the assertion of European sovereignty. However, the Supreme Court clarified in this case that Aboriginal title was not confined to specific sites of settlement or intensively used tracts of land like historic village sites, which was really the view of the BC Court of Appeal. Instead, the Supreme Court found that that title could be extended to areas of land that were regularly used for hunting, fishing, or foraging, provided that that group exercised effective control over the land at the time of assertion of European sovereignty. And this was quite important for the Chilcotin because they were a semi-nomadic people. Now, I do want to flag that in this case, there were some unique characteristics that made it easier to establish Aboriginal title. There were no overlapping claims, which is quite unique in BC, and the uniqueness and remoteness of the land made it easier for the Chilcotin to establish sufficiency and exclusivity. In particular, there was evidence that they demanded outsiders seek permission to pass over their land and that they kicked people off the land. There was also evidence that the land was harsh and capable of only supporting 100 to 1,000 people, which was relevant for the Chilcotin's ability to exercise effective control. In this case, the Supreme Court of Canada also talked about the incidence of Aboriginal title in terms of what that right affords. And they confirmed that Aboriginal title confers rights similar to fee simple ownership, except that the land must be collectively held. It cannot be alienated except to the Crown, and it cannot be encumbered, disposed, developed, or misused in a way that would substantially deprive future generations of the benefit of the land. In this case, the Supreme Court of Canada found that once title is proven, the Crown must either obtain the consent of the Aboriginal group for any developments on the land or meet the justification test, which includes considerations of whether or not the duty to consult was fulfilled. Now, this decision has raised Aboriginal expectations of consent generally, including in areas where there are treaties with land surrender provisions. There are several Aboriginal title claims that are currently before the courts, including a couple that are in trial right now, both of which raise novel issues. The first is a claim by the Cowichan tribes in BC, which is a claim of title over an area that is part of the city of Richmond. And as part of this, they're seeking a declaration that the fee simple interest granted by the Crown to private landowners in the claim area infringed their Aboriginal title. Now, the Cowichan are not seeking a declaration to invalidate the fee simple interest, but this will be the first case where the court has to consider an Aboriginal title claim over a portion of privately owned land, and the court will need to grapple with what this means, including with respect to damages against the Crown. The second claim I would highlight is the claim by the Saugeen Nation, which is a claim of two Ontario First Nations in the Georgian Bay area that are claiming Aboriginal title to the lake bed and a large portion of, to the lake bed of a large portion of Lake Huron and Georgian Bay. Aboriginal groups are increasingly asserting Aboriginal water title claims in consultation, but this will be the first time that a court has had to consider whether Aboriginal title can be established to a lake or riverbed, and if so, what that right affords and how that right is reconciled with significant existing third-party interests. That brings me to the end of my presentation on Aboriginal rights and title. Turn it back to Stephanie.
Thanks, Bryn. And just to, before I move on to UNDRIP, I think just worth mentioning in the Consultation decision, the Supreme Court of Canada made a number of comments about what consent means and when it is required. And essentially the findings are that Aboriginal title requires consent subject to the constitutional justification framework that we know now from Sparrow and Vanderpeet would apply. But we don't have any cases yet about whether an infringement of Aboriginal title is justified. So I think in the future we may potentially see a case go through the court where we're finding out what does it actually mean to be able to justify an infringement of Aboriginal title, where the standard would be extremely high. But otherwise, in all other cases in Canada, the duty to consult is the framework that continues to govern and that the courts continue to apply. The one comment by the Supreme Court in Consultation that was important, though, is they said, actually, as a practical solution to getting claims of Indigenous people saying that there's been infringement or unjustified infringements of claimed title or of rights, in a practical way, you could attempt to obtain consent before proceeding with a project or a development on Indigenous lands. And those comments have in some cases been construed as a broader consent-based framework, which is a little bit problematic from a legal perspective, but that's really that combined with UNDRIP and Canada's obligations now and commitments to implement UNDRIP, and the principle of free, prior, and informed consent in UNDRIP has created, I guess, a de facto expectation on the part of Indigenous groups that consent ought to be sought and obtained before proceeding. So that brings us though to part 3 about UNDRIP implementation in Canada. I know that you've had another presentation fully dedicated to UNDRIP, so today we just want to touch more about, based on this background that we've talked about now about rights, Aboriginal rights and title, and the constitutional protections and the legal protections that are recognized in Canada, and how broad and diverse and varied they are, what the concerns and difficulties are with overlaying this broad piece of a declaration onto Canadian law. So just very briefly, UNDRIP is, you will know, a non-legally binding declaration that the United Nations General Assembly adopted in 2007 and was not adopted by Canada until later. But it's distinct from a convention, a UN convention, which would be legally binding, and that's important in terms of Canada's international obligations. But Canada has committed to implementing UNDRIP, and it is attempting to move forward with legislation to do that, which Bryn will just briefly discuss in a moment. But essentially, UNDRIP describes the individual and collective rights of Indigenous peoples and sets international minimum standards for how they should be treated based on principles of joint partnership, good faith, and mutual respect. And the range of topics covered in UNDRIP are very broad: culture, identity, religion, health, education, community, and land rights. And from a project development perspective, I think the most important types of rights that are in there, and the ones that raise the most concerns, relate to lands and territories and resource rights, as well as rights of Indigenous peoples to make decisions with regard to those lands, and as well as the rights of redress, for example, or compensation for use of lands. And as Bryn also mentioned, the Consultation decision has been one driver for this emergence of consent as being a prerequisite to development in Indigenous territories. But as well, UNDRIP and the concept in several articles in UNDRIP of the requirement for free, prior, and informed consent prior to doing anything that might impact an Aboriginal right have been the main drivers for this increased expectation with respect to resource and project development in Canada. So I've just highlighted here some of the most crucial articles that often are noted or referred to in terms of what the requirements and expectations are on Crown and industry. Article 19, with respect to the requirement to consult and cooperate with Indigenous peoples in order to obtain free, prior, and informed consent before the adoption or implementation of legislative or administrative measures that might affect them. So that's quite a very broad type of article. 26.1, and I just ask you here to note the very broad use of terminology and how these terms are not defined anywhere. So Indigenous peoples have the rights to the lands, territories, and resources which they've traditionally owned, occupied, or otherwise used or acquired. So we've seen throughout our presentation how land rights are so varied: historic, modern treaties, unceded territories, land subject to self-government agreements, or lands where Aboriginal rights are merely asserted rather than claimed or established. Article 26.2, Indigenous peoples have the right to own, use, develop, and control lands, territories, and resources that they have possessed by traditional ownership or occupation. So this ownership right, if we were to apply it broadly in Canada, that could of course be a very, very broad requirement, an obligation to Indigenous peoples. And then Article 32.2 states shall consult and cooperate with Indigenous peoples in order to obtain their free, prior, and informed consent prior to the approval of any project affecting their lands or territories and other resources, particularly in connection with the development, utilization, or exploitation of mineral, water, or other resources. So essentially here, this is, I would say, overlaying the requirement from Silcoteen of Aboriginal title lands requiring consent to any type of traditional use or ownership, traditional territory rights for Indigenous peoples. So you can see how the law within Canada and the constitutional protections and framework that's been established doesn't jive very well with what is actually set out in UNDRIP. So what do we do about that? Here, you know, governments have a big job ahead of them in the provinces, the territories, and the federal government in having made the commitment to do these implementation measures. How are they going to, it's not a neat fit with simply saying we're going to apply UNDRIP in its entirety. There needs to be some degree of parameters and definition about how we're going to do it. So some of the concerns that have been raised and that Canada raised initially when it was opposed to UNDRIP, I've set out here, and these continue to apply. And essentially what the Senate in the federal government was grappling with when their failed bill C-262 last year didn't pass the Senate. And these were some of the concerns that had been raised. First, there was this lack of clarity about the terminology about lands, territories, and resources, and how do we define those? How do we reconcile these articles with this broad range of Aboriginal rights and interests in land, from hunting and fishing rights to cultural and spiritual rights, all the way to Aboriginal title? How does UNDRIP, how do we compare that against the legislative regimes, the treaties, historic and modern, and other protections that Canada has applied over Indigenous rights and land rights in Canada? And then fundamentally, how do we make it compatible with Canada's constitutional framework? Does the concept of free, prior, and informed consent override this established duty to consult? Does FPIC constitute a veto, or is it merely an aspiration to get to consent? When there's self-government provisions in UNDRIP, does this take into account sufficiently the paramountcy of federal and provincial laws over those lands as well? As well, in UNDRIP, there's really very little recognition for the rights of other Canadians and the rights of the Crown, and this need to balance the Supreme Court of Canada has largely set out. But I think one of the provisions in UNDRIP that is often overlooked is Article 46.2, and that really sets out the parameters for saying that when states are trying to implement the declaration, there are limitations that they may take. The limitations are subject to what is determined by law and in accordance with international human rights obligations, as well as limitations being non-discriminatory and necessary in order to secure due recognition and respect for the rights and freedoms of others, and for meeting the most compelling requirements of a democratic society. So that's really the balancing provision of UNDRIP, which I think the governments are going to be needing to consider when they're looking to implementation. And then lastly, I just wanted to point out the comparative approach between the federal approach in their new Impact Assessment Act versus BC's approach in its Revitalized Environmental Assessment Act, where these are really the primary example at this stage of how the governments are looking to implement these concepts, particularly of free, prior, and informed consent. So in the federal approach, it's essentially a discretionary powers that have been given to the minister and the agency about entering into agreements and arrangements or substitution and delegation powers as a means of negotiating consent, essentially, in certain situations. Whereas in BC, I think they've taken a more nuanced approach and have actually set out that there are two opportunities for consent or lack of consent to be communicated at the EA readiness phase, and then whether to issue an EA certificate. And then the focus is, let's seek to achieve consensus. And if we cannot do that, there's a dispute resolution mechanism. So they've really attempted to draw it out a little bit as to what a consent-based approach might be. Bryn, do you have anything to add before we move on to any questions?
As well. Hello. I don't have anything to add. I think you've covered this well, and I think we are at our time in any event.
Great. So
Okay,
I think
Stephanie and Bryn, I think we're at our time, and so we'd like to open it up to our participants to submit questions through the question box. So right now we'll just give a couple minutes for people to prepare and submit questions. In the meantime, I'll start off with a question. So aside from British Columbia, what are other provinces and territories doing with respect to the implementation of UNDRIP? So can either of you comment on that?
Yeah, sure, I can comment on that. So aside from British Columbia, there is only really one other jurisdiction, aside from British Columbia and Canada, that's taking concrete steps to implement UNDRIP, and that's the Northwest Territories. The Northwest Territories is committed to implement UNDRIP, and it's right now working. It doesn't have legislation that's been drafted, but from what I understand, it's working with Indigenous governments to create and implement an action plan that will identify changes required in territorial legislation and policies that best reflect the principles of UNDRIP. And so then aside from the NWT, the provinces really kind of fall, and remaining territories really fall within two buckets. I think there's the provinces that are either opposed or not likely to proceed with implementation unless there's change in government. And that's really the largest group, and included in that is Manitoba, which is which their premier has been publicly opposed to federal government efforts to implement UNDRIP. I think Ontario is unlikely to move forward with UNDRIP implementation efforts under this current government. I know that there is a private member's bill that's similar to the federal legislation and the BC legislation, but I don't think that that's likely to pass. The Alberta government is opposed, and I think of the remaining, I think Saskatchewan, Quebec, and Newfoundland and Labrador are also unlikely to move forward with any efforts to implement UNDRIP under the current government. The only other jurisdictions left of that is Yukon, Nunavut, and Prince Edward Island, and they each have expressed support for UNDRIP, but haven't really taken concrete steps to implement, and I think are watching the federal government's efforts, and then will likely proceed after that.
Thanks for that, Bryn. Stephanie, I'll direct a question to you. Are there any recent trends in Aboriginal litigation or upcoming cases to watch?
Sure, yeah. I think one of the ones, Bryn mentioned it briefly in his comments, but the treaty infringement claims that are occurring. Bryn mentioned the Blueberry River case, which is in British Columbia. There's also two other claims, the Beaver Lake Cree in Alberta and Carry the Kettle First Nation in Saskatchewan. And essentially, these treaty infringement claims are made on the basis that the cumulative impacts of resource development and activities within their traditional treaty territories have deprived the Indigenous peoples of the ability to meaningfully exercise their treaty rights. And so it will come down to whether or not there has been an infringement of a treaty right, and second, whether or not those infringements are in fact justified, and if not justified, what is the remedy? Would that result in a permanent injunction in certain areas, for example? And just to give you an example of how significant this decision is, I mean, the Blueberry River Treaty 8 territory is up in the Peace region of British Columbia in the Montney Range, where there is a whole lot of industrial activity. A report was done recently that indicated that I believe about 91% of their treaty territory was within 500 meters of an industrial disturbance. So it's not an insignificant claim. The Supreme Court of Canada has noted that these types of claims can be viable and may happen. So it's definitely an important case to watch. And when Blueberry River moves forward, we'll see what the other cases in other provinces might do. But certainly treaty rights infringement and this focus on cumulative impacts is an important continuing trend and will continue to be increasing as a trend. One other type of claim I think to keep an eye on are private claims against industry versus the Crown. Typically when there's been Indigenous infringement or failure to consult claims, they're typically against the Crown, where the proponent is the third party. I'm referring in particular to the Sycus and Stellatan claim against Rio Tinto Alcan with respect to the Kenny Dam. And what they claim is that the dam has impacted their riparian rights to the river, and they're claiming private and public nuisance against the company on the basis of unproven Aboriginal rights. And what's interesting though is this is sort of a property rights analysis and framework where you would typically need proven rights in order to bring a claim like that. So it'll be very interesting to see how that moves forward. And the trial began last October. It was a 200-day trial, so I'm not sure exactly where it is at the moment, but I would expect that there will be a decision relatively soon, that at least a trial decision that will inevitably be appealed.
Okay, thanks for that, Stephanie. I encourage all the participants to submit any questions. We only have a few more minutes left. I have a question myself. Just so when we look at the history and sort of provincial and federal implementation of the duty to consult, some notions of delegation of procedural aspects to industry, where do we see that will we see that approach as we begin to look at implementation of UNDRIP? So will there be an expectation of industry to implement the principles of UNDRIP in their project development, project decisions? And I think, we've taken 15 or 20 years, I think, for people to become familiar with the duty process, the bookends that have been established by the Supreme Court, and it's kind of like we're hitting a reset, starting on a whole new path that still is not completely defined. Any more comment you want to make on that, Bryn?
Sure. I mean, I think it remains to be seen how the federal government is going to implement the provisions relating to pre-prior and informed consent. I don't think that they're going to throw out the duty to consult framework. I think the duty to consult framework is going to remain in place based on some of the statements that they've made publicly to date. But really what's unclear is they seem to be saying that it's the duty to consult plus in some circumstances without explaining what that plus is. And that's a real problem, I think, for Indigenous groups and for industry. And their lack of clarity is problematic because it's creating expectations on the side of Indigenous communities that consent is going to be required, when on the other hand, it appears that the federal government is implementing it as consent with an objective, and maybe greater efforts to obtain consent, but not consent being an absolute requirement. And so what I think, you know, and I'll echo Stephanie's comment earlier, I think that the federal government is going to continue to rely, as will other provinces, continually to rely heavily on proponents to discharge this obligation. And frankly, I think proponents are better placed to be consulting about their projects. They know their projects. They're best able to answer questions about their projects and introduce, make changes to their projects. And, you know, the government, particularly the federal government, doesn't have a great track record on consultation when it gets involved. And so, you know, I think it will still be pretty proponent heavy. I think there will be greater expectations on proponents to try to achieve consent, and greater scrutiny of efforts to achieve consent and accommodation. And there will be some additional, I expect, involvement of Crown officials, and particularly for certain projects where there is a potential high degree of impact. But I still think it's going to be a largely proponent-driven exercise. But the key thing I think will be to push the government for greater clarity, or federal government and BC government too, for greater clarity in terms of how they see the rules of Indigenous engagement changing, if at all.
Thanks for that, Bryn. So there are no further questions. So I'd like to thank our two panelists and all our participants. And I'm going to turn it over to Rewa from the CEA for some closing comments.
Thank you, Wayne. Thank you, Stephanie and Bryn, for a great presentation and a really great discussion. Before we end today's webinar, I would just like to share with all of our participants that our upcoming conversation series webinar will be held on October 29th, which is tomorrow. Contact Point 360 will be presenting on using artificial intelligence and speech analytics to monitor, track, and improve customer experience. And on November 3rd, we have Omicron, who will talk about digital substations and IEC 621-850. All of CEA's future events and webinars can be found in our monthly newsletter, Current Affairs, as well as on our news and events section on our website at electricity.ca. If you would like to view the recordings of past conversation series webinars, they can be found on our website at electricity.ca in our Learn section under the Library tab. Thank you again for joining us today. Until next time, bye for now.